Warning, graphic details follow. A Sarnia doctor must pay a former colleague and friend he pinned down and sexually assaulted in her home $200,000 in damages, Ontario's top court ruled last week. Dr. Syed Nasir Ali argued in his appeal that the damages he was ordered to pay to a former colleague were too high. Dreamtime, Dr. Syed Nasir Ali, who maintains an active license to practice medicine, had been found liable in civil court last year for sexually assaulting Drive B in 1999. On top of the $175,000 in general damages and $25,000 in punitive damages, he must also pay $155,700 in prejudgment interest, $325,000 in court costs and an additional $15,000 for costs related to his appeal, adding up to $695,700. At the Ontario Court of Appeal, Ali abandoned his appeal on the issue of liability, but maintained the amount of damages awarded to Dr. B by Superior Court Justice Joanne Morissette was too high. A unanimous three-judge appeal panel disagreed with him. Ali's appeal lawyer, John Adair, declined to comment to the Star. Article continued. Below, among other things, Ali had argued that the range of damages Morissette relied on when she ordered him to pay $175,000 in general damages was unsuitable, according to the appeal court decision, because that range applied to cases of severe sexual assault involving repeated abuse and breaches of trust. A civil case requires a lower burden of proof than criminal cases, which is proof beyond a reasonable doubt. In civil court, it must be proven that it was more likely than not that the alleged incident occurred. The Star is not naming Drive B as it does not identify victims of sexual assault without their consent. In his case, Ali was found by Morissette to have pinned Dr. B down in her home when he was visiting on the pretext of completing a medical form. At one point while Drive B was bent down in her den plugging in the air conditioning, Ali came into the doorway naked. He then tripped her and lowered her onto a rug, according to Morissette's decision. While she pleaded for him to stop, he penetrated her and then ejaculated on the carpet. Dr. B had testified at the civil trial. Ali then put his clothes back on and asked for a ride back to the hospital, to which Dr. B agreed. Ali had testified at the trial that he and Dr. B, who were both married, were engaged in an extramarital affair, which she denied. The rug ended up being a crucial piece of evidence at the civil trial. Ali had denied having any contact with it. But in 2001, Dr. B had the rug tested, which confirmed the presence of semen. She then had a friend take a ceramic mug which Ali had been using at a department meeting. Court heard that the DNA on the rug was a match to the DNA on the mug. Ali continued to deny ejaculating on the rug, but refused to provide a DNA sample. Article continued. Below. This week, a spokesman for Ontario's medical regulator, the College of Physicians and Surgeons of Ontario, said the college is investigating Ali. On appeal, Ali argued he should have to pay no more than $50,000 in general damages. He contends that this was a single incident involving persons of equal status, and that there was no evidence of any long-term psychological trauma, wrote Court of Appeal Justice Catherine Van Rensburg for the appeal panel. In assessing the severity of this sexual assault, it was open to the trial judge to adopt the range that she did, Van Rensburg concluded. This was a case of sexual assault with penetration by a colleague and friend in the victim's own home. The court also rejected Ali's argument that he should not have to pay $25,000 in punitive damages, which Van Rensburg said are awarded when a defendant's misconduct is so outrageous that such damages are rationally required to act as a deterrent. Ali argued that Morissette assumed punitive damages were required because he had not been charged criminally with sexual assault. Dr. AFB did report the incident to police. The trial judge's decision with respect to punitive damages was based on the fact that the appellant's conduct in sexually assaulting the respondent was morally reprehensible and should be punished and denounced, and that he had not been punished criminally. Van Rensburg wrote, "The fact that he had not been punished criminally was a relevant factor to satisfy the court of the need for such damages as deterrence, but was not the reason punitive damages were awarded." Jacques Gallant is a Toronto-based reporter covering legal affairs. Follow him on Twitter, @JacquesGallant.